Okay, we're in the home stretch. We're at the pretty much the last section that deals with real estate and transferring that real estate to the trust, or the legal terminology is funding the living trust with real estate. This includes three different options that I'll discuss and explain within this form separately. Um, Transferring uh, real estate that's owned outright by the clients. In other words, there's no one else on the title, just the client or clients, if it's a couple, to the trust. Uh, Removing a deceased person from title, which would be this option here. Preparing an affidavit of death of joint tenant. If there's a deceased person on title, the first one was transferring the property to the trust was the first option here. And then finally, preparing a deed to remove a non-owner who's still alive, obviously, from title, such as a co-signer, someone who helped the clients qualify for a loan, but who is not technically, per agreement between the clients and the co-signer, an owner, not an owner of the property. In most cases, we have to remove that person from title. Um, Go ahead and include that option. Don't worry about the property tax consequences. I'll figure that out when you submit this form to me. I'll determine whether or not that's going to trigger a reassessment. I've got 18 years of experience working with the county assessors in California, and I know virtually most, if not all, the different scenarios that play out when you have an additional person on title who is not technically an owner, and uh, removing that individual from title, whether or not it'll trigger a reassessment. There are different scenarios that affect reassessments. So I'll examine that. I'll do a chain of title search and confirm whether or not that'll happen, and then advise you accordingly to let the client know, and what the potential solutions to that would be to prevent a reassessment, workarounds, for example. But for now, we're going to start with this option here. When you finally, well, basically, this particular explainer video that you're watching now is the one dedicated to transferring the property to the trust. That's when there's no other person on title, just the owner or owners, no co-signer, no deceased person. That's this option here. You'll see links here. I'm going to try and um, manipulate this software for this page to show three links here that will describe each of these three options here. Okay, so let's go with this first option. Click next, and you'll come across this page here, property number one. If there's only one property, you only have to deal with that property. You don't have to add another property. That's the principal residence of the client. If they have more than one property, rental properties or a vacation home, or a vacant piece of land, that's considered a separate property. You would add another property after you fill this one out. Okay, fill the information out for this one. Okay, so it's going to ask if you want a detailed explanation of the different methods of real estate interest. In other words, manner of title, how title is held. And I'm only going to cover three of those for now, the three most important. So if you want that detailed explanation, and you should understand what those are and how they work within this living trust framework in order to make these decisions here. So it's going to ask you if you want to choose the outright ownership, which is the most common. That's when the clients own the property only in their names, and there's no other person on title, whether it's a deceased person, no co-signer on title. Now, of course, if there are situations where a couple bought the property with another couple, let's say it's a duplex, and two couples that happen to be friends or related couples in a way, decide to purchase the property together, and one couple stays in one fixed part of the property, one building, and the other couple stays in the other part of the duplex. That'll be partial interest tenancy in common if they hold title as tenants in common. If they hold title in that same exact scenario where two couples bought the property together but they're all joint tenants, that'll be this option here. Okay, but let's talk about first outright ownership. Before we get to that, we'll click on this button here, and it brings up the explanation menu. giving you a detailed explanation of what outright ownership is, also known as fee simple, what partial interest is, aka tenancy in common or tenants in common, and then joint interest. Don't be confused with outright ownership where a couple owns the property together as joint tenants. That does not apply. This section here, number 3, joint interest, which is also right over here, joint tenancy interest with other individuals, that does not apply to outright ownership if the couple are the only owners and no one else is on the title of the property. So read this. You'll understand when you read this, and also look at the video, the in-depth video explanation about the concepts behind these manners of title or ownership interest types. So if it's joint tenants just with the husband and wife or the registered domestic partners or the 2 lifelong partners, and there's no third person on title as a joint tenant, it's outright ownership interest. If it's a joint tenancy with other people that are not technically, per agreement of the clients, not an owner, that would be joint interest with other individuals. Okay, very critical to understand the difference between that, those 2 concepts, those 2 scenarios. This video link is the same as this link here. Okay. Now, I'll also probably put the page tutorial link to this video for real estate transfer to the trust here as well. You'll see that in case you want to refer back to it while you're filling this out. So we go outright ownership interest because the married couple owns the property, just husband and wife as joint tenants. How is the property currently vested? Is it in both names or is it in the husband's name only? Yeah, let me backtrack a bit. So outright ownership for a couple could also include ownership by the wife only or ownership by the husband only. Okay, no one else on the title. Again, using that same example when it comes to joint interest. If it's ownership between, let's say, the husband and the brother-in-law, or the husband and one of his brothers or his sisters, or the husband and one of the children, that would be option number 3, joint interest with other individuals. So joint interest, in other words, joint interest with other individuals applies when there's a joint tenancy and there are other people besides the clients on the title. That's where number 3 would kick in if it's easier to remember that way, understand that way. So let's just say, for the sake of demonstration here, both names, the properties in both names, the husband and wife as joint tenants. You select that, both names, boom, you get these fields that pop up. Enter the husband's name as it appears on the deed. Okay, and make sure when you enter, select yes, that the names are spelled correctly. Property information, you select whether that property is the client's primary residence, which if it's the only property that they're listing here, it's more than likely their primary residence. Enter the parcel number. You'll get that from the property tax bill or from a deed that was registered relatively recently. Back in the day, in the old days, probably prior to 95, parcel numbers sometimes were left off of these deed transfers, and the identification of which property was being affected by that deed was determined by the legal description only, and it still is to this day. The county assessor determines a transfer of property and which property that applies to based on the legal description. It's extremely important for the legal description, but I'll get to that in a second. Address, county where it's located, state, zip, city where it's located. And again, when you enter the address, follow the proper protocol, proper formatting for address. Please be very critical of that. And it'll be very helpful to upload a photo of the property tax bill, the most recent property tax bill. You can upload that there. Type of deed that we're going to be doing. Okay, this is the type of deed that we're going to do. Just for this purpose, always select quitclaim deed. Don't worry about grant deed. We don't do grant deeds to transfer the property. I mean, you can. It's either one is fine. But in this case, a quitclaim deed to the trust is more than sufficient, where the couple will be quitclaiming the property to their living trust with them still appearing as owners, but as trustees of the trust. And then, of course, you enter the legal description. Okay. Do your best to get this legal description. I will do my due diligence and determine the exact legal description and confirm it's correct with the county assessor records and the last deed that I will pull as part of this service. I will download from from my title company. But if you have it, go ahead and enter it here. Okay, try to be accurate with it. But if it's not, don't worry. I'll get that. And then if they have a second property that they're going to put under the trust that the clients are the sole owners of, you'd add another property. Okay. Property number 2, property number 3, property number 4, whatever number of properties they have that they want to put under the trust where they are the sole owners. Okay, then you'd use this section for that. So I hope that helps. And now we'll move to the next section, which would cover partial interest transfers or tenancy in common.